the nature and the seriousness of the offences of which you have been convicted of, as well as the interest of society. Yes. Starting with your personal circumstances. These are the circumstances as outlined by your respective legal representatives and are the following. Accused number 1, Mr. Doorwaard. You are currently 28 years of age. You were 26 years of age at the time of the commission of these offences. You are a first offender. You are the youngest of 3 children. You matriculated at Potch Gymnasium School. During 2013, you attended at the Northwest University and successfully complete a BSc degree in tourism. During 2014, you went to Kansas in the United States of America doing agriculture and returned in 2015 to South Africa. Upon your return, you concentrate on farming activities on the farm of your relatives. You are unmarried, but have a but are in a relationship. You are experiencing good health. That is as far as your personal circumstances are concerned. Mr. Skitter, your personal circumstances are the following. You are currently You are currently 35 years of age. At an early age, you were diagnosed with dyslexia, a difficulty in learning to read and interpret words, letters, and symbols. Despite this, you went as far as grade 10 at school, and thereafter you attended a training college in Porch, but you went up to the second year and had to drop out. You assisted your father with the farming activities, and you are the last born of 3 children. During 2004, you went to England for 6 months. Thereafterwards, you returned, and you were also a farm manager in Botswana for a year and a half. You were also employed as a lorry driver at NWK, and for the last 3 years, you were employed as a workshop manager and farm assistant on the farm of Mr. Peter Karstens. You are married and have 3 minor children, aged 7 years, 5 years, and 3 years respectively. Your wife assists at the guest house of her parents in Parijs in the Free State. You are the breadwinner and you earn a net salary of 12,000 rand per month. Like accused number 1, you are also a first offender. I am informed that you are on medication because of hypertension. You are suffering from distress and depression and even lost weight in excess of 40 kilograms. That is as far as your personal circumstances are concerned. Coming to the nature and the seriousness of the offenses of which you are convicted of, murder is undoubtedly the most serious offense that can be committed. The deceased has lost his life at the age of 15 years, and both of you referred to him as a child. Years. The deceased was 15 years of age. This court must have regard to the circumstances under which the deceased met his untimely death. According to you, the deceased and his friend allegedly stole sunflower. There is no certainty how many heads of sunflower were allegedly stolen and what the value thereof was. On the version of Mr. Pakisi, which this court accepted as honest, truthful, and reliable, a gunshot was discharged in the sunflower field. Accused 2, you emerged on a quad bike and drove towards the van where accused number 1 and the deceased were. You picked up the deceased and you threw him from the van onto the ground. As you pointed out, the deceased was a child, and it was not at all necessary for him to be thrown from the van in order for him to sustain that fatal injury. If it was indeed necessary to apprehend him and wanted action to be taken against him, you could have employed other means and measures rather than to punish him as you did. If that was not enough, when you noticed Mr. Pakisi, you confronted him and forced him to get onto the van against his will. You kidnapped and assaulted him. You even caused him to drink liquor and to eat his vomiting. You fired shots at him and intimidated him. You also pointed him with firearms. And his cell phone was also taken away from him. Your actions on that day towards Mr. Pakisi and the deceased were indeed disgraceful and appalling. Mr. Pakisi in particular was subject to very inhumane treatment at your hands for being at the wrong place at the wrong time. All this was done to Mr. Pakisi because he observed what you were doing to the deceased. This court must also take into account the interest of society. It cannot be ignored that the community revolted as a result of this incident. This, to my understanding, was largely because of the inaction on the part of the police to perform their duties and to do so diligently. This resulted in the community resorting to self-help. Businesses were looted, houses were demolished, and the community protested violently. In the eyes of the community, as testified to by Mr. Nyakama and Mr. Tselo, the community of Coligny was polarized as a result of this incident. Mr. Tselo. Mrs. Mosweu, the mother to the deceased, also testified in aggravation of sentence. She testified about the devastating effect that the death of the deceased had on herself and her family. This court will take into account that endeavors were made by you in order to meet with the next of kin of the deceased, although belatedly, in an attempt to express your condolences with the passing of the deceased. The legislature enacted what is commonly called the Minimum Sentence Act. That is the Criminal Law Amendment Act 105 of 1997 as amended. This act prescribes to the court what sentence should be imposed as a minimum sentence for certain type of offenses. This act is applicable with regard to count 1, that is the count of murder, in that both of you acted in concert with one another in furtherance of a common goal or common purpose, and never dissociated from the actions of each other. when two or more persons acting in furtherance of a common goal or common purpose brings about the death of a person, the sentence prescribed in terms of the minimum sentence act is that of life imprisonment. Unless there are substantial and compelling circumstances present which warrants a deviation, this court must impose life imprisonment as a sentence on count 1, that is the count of murder. This court carefully considered whether there are indeed such circumstances present in this case and came to the conclusion that there are. The following are found to be substantial and compelling circumstances. 1. The offense of murder was not planned and premeditated, but it happened at the spur of the moment. It can be induced from the evidence of Mr. Pakisi that there must have been a chase resulting in the apprehension of the deceased, and after the deceased was apprehended, he was thrown head first from the van by accused number 2. Two, there was no direct intention to kill the deceased. This court found, based on the applicable legal principles, that the intention was in the form of dolus eventualis, in that the accused must have foreseen and in fact foresaw the possibility that by throwing the deceased head first from the van may result in his death, and acted recklessly with regard to the ensuing consequence. I can't hear you. I repeat. There was no direct intention to kill the deceased. This court found, based on the applicable legal principle, that the intention was in the form of dolus eventualis, in that the accused must have foreseen and in fact foresaw the possibility that by throwing the deceased head first from the van may result in his death, and acted recklessly with regard to the ensuing consequence. Thirdly, the fact that you are first offenders. And fourthly, your personal circumstances as a whole, taken cumulatively, is indeed substantial and compelling enough for this court not to impose life imprisonment as a sentence. However, the aggravating features of this case by far outweigh your personal circumstances and mitigating features. Your moral blameworthiness are more or less similar, except for the fact that it was accused number 2 who actually picked up the deceased and threw him head first from the van onto the ground. This difference will be displayed in the sentence that the court will mete out. Mercy is also an element that the court must take into consideration in imposing an appropriate sentence. This court is mindful of the fact that none of these factors and circumstances should either be over or underemphasized, but need to be carefully balanced in order to arrive at an appropriate sentence. In order to guard against imposing too a severe sentence upon the accused, the court will order that some of the sentences on the various counts should run concurrently. Ask the accused to stand. Having considered all the aforementioned facts, factors, and circumstances, I am of the view that the following would be appropriate sentences under the circumstances of this case. Accused number 1. Accused number 1, on count 1, that is a count of murder, you are sentenced to 15 years imprisonment. On count 2, that is a count of kidnapping, you are sentenced to 3 years imprisonment. On count 3, that is a count of intimidation, you are sentenced to 2 years imprisonment. On count 4, that is a count of theft, you are sentenced to 1 year imprisonment. On count 7, that is the count of pointing of a firearm, you are sentenced to 2 years imprisonment. It is ordered that the sentences on counts 2, 3, 4, and 7 should run concurrently. So accused number 1, you will effectively serve 18 years imprisonment. Accused number 2, on count 1, that is the count of murder, you are sentenced to 20 years imprisonment. On count 2, that is a count of kidnapping, you are sentenced to 3 years imprisonment. On count 3, that is a count of intimidation, you are sentenced to 2 years imprisonment. On count 4, that is a count of theft, you are sentenced to 1 year imprisonment. And on count 7, that is a count of pointing of a firearm, you are sentenced to 2 years imprisonment. It is It is ordered that the sentences on counts 2, 3, 4, and 7 should run concurrently. So accused number 2, you will effectively serve 23 years imprisonment. This court will now adjourn.